Former OSP friend Martin Amidu ene waba nsɛm bi aba abɛto ne nsɛm a ɔde aba abɛto abusua wa expose former president Akufo-Addo on OSP ne office na okreti ene ɛkwan a ɔfa so ɛde saa office no ɛdi bɔne nti na ɔno kora ɔba abɔnten ɛba abɛ criticize the former president Akufo-Addo a ɔkyerɛ sɛ ɔyɛ mother serpent of corruption. Abusua aha gossip politics TV. So unsubscribe ya, subscribe na hit on the notification bell so that any update be ever dropping on. Also once every to me akabina or this and somebody better jano. Papa ye friend kissi Agyabeng there. Oshe de wa nyoma se bi kona oshe law na articles 88 na omo ka ho asem no. Papa na de hwe enkyere se or beba back to any officer. See, a Martin Amidu and so Edin Sembi Abetuja was schooly with a legal wisdom. Mamian corner, young Kokoti, Midamase.
The former special prosecutor or the first special prosecutor of the Republic of Ghana, Martin Alamisi Burns Kaiser Amidu, has also been writing about this. He says the relationship between the special prosecutor and the Attorney General under this government has broken down beyond repair. But Dr. Shem Sai says they have a good relationship. They've been collaborating and working, okay? And then again, whose report are you going to believe? It's a matter that obviously has to be gotten into. The Attorney General's statement of case does not appear to objectively, neutrally, and impartially present an ethical response to the plaintiff's case. And in this matter, they're talking about, he's referring to Noah Adamte, that's Tete's case. He says that the Attorney General's statement of case does not appear objectively, neutrally, and impartially, and in fact present an ethical response to the plaintiff's case. There was no turf war between the Special Prosecutor and the Attorney General during my tenure to warrant a challenge about the constitutionality of the said office, the Special Prosecutor. Martin Amidu continues that the Attorney General's statement of case does not even hide his partisan interest in the plaintiff's case when he fails to show which portion of the plaintiff's case the court should dismiss. This is just portions of Martin Alamisi Burns Kaiser Amidu, the former special prosecutor's position on what has been playing out between the Attorney General and the Special Prosecutor's Office. On the matter of authorization, here Justice Adam Shrem says the Special Prosecutor does not want to come for authorization. We understand the Special Prosecutor's position is the office is independent, so why do they have to come for authorization? But then you hear the Attorney General, the Deputy Attorney General, reference Article 88 of the 1992 Constitution. So at the heart of all of this is whether or not the Special Prosecutor needs authorization to prosecute cases that it is pursuing. Lawyer Henry Mamhesi, good evening to you. Thank you so much for joining us here on Ghana Tonight.
Good evening and thanks for having me. Christian.
Are you able to put the video on for us?
Yes.
I think
it's on.
No, unfortunately, it's not. Oh, okay.
It's on. It's coming from your side.
Okay. I think you just have to put it on for us while we run through. But I'm just going to kindly stay with me while I run through Article 88 of the 1992 Constitution, specifically on the matter of the Attorney General, the reference that he makes. That one, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. Two, the Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President, or imposed on him by this Constitution or any other law. Three, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. And this is where the emphasis is on, Article 88.4. All offenses prosecuted in the name of the Republic of Ghana, shall be at the suit of the Attorney General or any other person authorized by the Attorney General in accordance with any law. This is where the issues really are, and why all of this is playing out the way it is as we speak, and also why the Deputy Attorney General, you hear him raise issues regarding the position that the Special Prosecutor has taken on this particular issue of whether it needs authorization or not. Let's go to Christian Mamahese right now. He is private legal practitioner. Counsel, good evening. Can you hear us clearly now?
Good evening, and thanks for having me.
And first of all, I want to find out from you your thoughts on this, how this matter has been playing out, and listening to the Deputy Attorney General specific on the matter of authorization. He says, well, the law is clear in Article 88.4. That is what they are only going by the orders of the High Court to execute what the High Court has told them to do. And if the Special Prosecutor needs authorization as enshrined in the law, he must come. It will only be an issue if he is denied authorization on any case that he is prosecuting. Then we can talk about a turf war. Until then, he says there is none. Your thoughts on this?
Yes, good evening to you and your viewers. Indeed, I mean, we are governed by rules and regulations. And in legal theory and jurisprudence, for a legal society or for a legal system to exist, it is hedged on secondary rules. And secondary rules are meant to ensure that there is certainty in law, which cures the primary rule, where in the primary rule there is no uncertainty. Indeed, the OSP Act was promulgated in order to cure a certain mischief which existed in the primary rule. Now, the OSP Act, as it's presented, has section, aside the objects of it, and then looking at section 1, section 3, and section 4.2. Section 4.2 deals with the fact that the OSP has to seek the authorization of the Attorney General when it comes to its prosecutorial powers. Now, when you look at the objects of it too, it indicates that the OSP is vested with both investigative and then prosecutorial powers. Now, the first one is very, very, very solidified. The second one makes the OSP subjudicated to, or its function of prosecutorial powers is subject to that of the Attorney General. So, in the quest for the OSP, whenever it seeks to prosecute any of its corruption and corruption-related cases in court, then it needs that authorization or executive instrument from the Attorney General's office in order to do so. And where it seeks to carry out that, then we would say that there has been a statutory breach. And to that extent, that statutory breach ought to be cured in order for the OSP to have recourse to that particular function. Because by the wording, by the text and context, or the statutory interpretation of it, subject to Section 10 of the Interpretation Act, the OSP is enjoined to seek that clearance or such leave or such authorization from the Attorney General in order to carry out that function. It does not mean to say that the OSP's prosecutorial powers has been taken away from it. No, because we have other state prosecutorial agencies that seek same leave, or when we say leave is permission, that seeks such leave from the Attorney General to carry out such prosecutorial functions. And for the fact that the Act that gave birth to the OSP never gave the OSP that autonomy in terms of prosecutorial powers, then whatever is vested or whatever is crafted in that particular act is the function that OSP must carry itself in. So OSP cannot carry itself out of that particular function, but the the grand norm, that is the law that or the rule that it traces its powers to, is that which it must rail itself and function accordingly in order to attain the ends of whatever it seeks to do. So in all of it, it is more of a collaborative function between the office of the OSP and that of the office of the Attorney General.
Do you get the sense that do you get the sense that that collaboration still exists, or, as it were, Martin Amidu says there's clear indication that collaboration has broken down, and that's why it's playing out the way we are seeing it right now?
I mean, obviously, to the general public, the cracks are showing, and indeed, the only way that this could be rectified is where the Constitution is amended in terms of the powers of the Attorney General, and it is for the framers to decide whether this subjudicated authority would exist between the Attorney General's office, or yes, the Attorney General's office and the OSP, or it would decouple the OSP to run a parallel prosecutorial powers with the Attorney General. Because if you look at the statute, it is what it is. And indeed, if you further verse to what the court did at GJ10, the court has every right in order to deal with constitutional matters. I mean, I am at odds with a number of lawyers who have been on other platforms to say that the High Court had no jurisdiction in dealing with constitutional matters. And I shudder to say that.
Not necessarily constitutional matter. There was the question was about the interpretation, the powers of interpretation, which is the exclusive jurisdiction of the Supreme Court, is it not? I mean, I think that's quite clear and it's elementary. Now, that was where the High Court's powers were called into question on the matter of whether or not it had the power to interpret the specific provision of Article 88 as and how it impacts on the law that establishes the office of the special prosecutor. That was where the matter of the Supreme Court having the powers, the exclusive jurisdiction to interpret.
If I would hollow a bit on it, I would say that yes, under Article 21 and Article 130, individuals can bring matters to the Supreme Court for constitutional interpretation. And in dealing with the Supreme Court's powers are vested in exclusive original jurisdiction, enforcement powers, final appellate jurisdiction, and then supervisory jurisdiction, including habeas corpus and mandamus. Now, if you come to the High Court also exercises general jurisdiction in criminal and civil matters. It also has jurisdiction in fundamental human rights, referral matters under Article 132, and also when it comes to interpretation, it has a limit to what it can do. Now, this limit was hallowed in the case of the Republic versus Mike Kankan and others in 1971, 1973, where it indicated that when it has to do with ambiguity, then the High Court ought to refer the matter to the Supreme Court, because if it does not do that, then it is extending its powers into unwelcome territories, and that would cause that decision to be quashed. Now, it was further enforced in the case of ex-party Dr. Zenator Agyabeng Rawlings, where the Supreme Court had the opportunity to say that when it comes to constitutional interpretation, the High Court can only engage in what we call the application, so that we have just made it in the simple terms that the litmus test is, will the High Court exercise applicatory jurisdiction to constitutional provisions? If it seeks to do that, then we say that the High Court's powers is intact, or its jurisdiction has properly been invoked, albeit so that the High Court will deal with the normal constitutional matters that comes before it. But then if it has to do with enforcement, then that would mean that the High Court would have to stay proceeding. That was what what's his name?
Okay, so I get the point. I think you've established the issues to the perspective of how far the High Court can go in the matters of interpretation. This is a matter that is rolling out in many ways. So we're going to stay the steam on it, and as we await how things will play out in the coming days. Christian Mamhesi, thank you very much for joining us here on Ghana Tonight. He is a private legal practitioner. Now, coming up next.
Okay, abusua winning and some so our political highway so former OSP and I nka ye odisa and some no tuja edimaya enye asam keto akra but am say some jepene kokoti and some way edimaya aha gossip politics TV so medam say